Thank you very much. It's a pleasure to be back here. I was at this conference last year, and it's great to be back again. And they will find my slides in a minute. Good. Steve Jobs. We've all heard of him. Talking about designs. People think it's a veneer. That designs are handed this box and told, make it look good. And that's not what we think design is. It's not just what it looks like and feels like. Design is how it works. And obviously, both in Europe and in the United States recently, we have had a lot of fallout from Mr. Jobs' view of the importance of designs. I will touch very briefly on the Apple-Samsung decision cases in the United States, just looking at some of the patents which are involved. And then we have further discussion on the European aspects and the role of Düsseldorf in that, I think, coming up. Designs really sort of sit at the intersection of all of the big three, if we can call them that, of intellectual property rights. They've got patent aspects, they've got copyright aspects, they've got trademark aspects. In some countries, France, for example, copyright is still an important thing for protection of product design. In the UK and in the EU, we have unregistered design rights, which are infringed only by copying the copyright approach. Other countries, Germany, unfair competition law is important. Scandinavia, Netherlands, I think, as well. They have marketing laws that have aspects of trademark protection. You cannot slavishly copy, as they say, somebody else's product and put it on the market. But I'm talking about mainly the United States, and in the United States we have some limitations on these other forms of protection. Copyright might seem to be a good way to approach things, but we have the view that copyright is really there to protect artistic works. We had a Supreme Court case 40 years ago about a base for a lamp, Maser against Stein. And the base of the lamp was an artistic statuette. And the Supreme Court said, yes, under those circumstances, a useful article could perhaps be protectable by copyright. And that has now come into the statute, basically saying that if the design and utilitarian aspects of something are conceptually separable, then can be identified separately, then, but only then, can we have copyright protection. So as a practical matter, except for jewelry and belt buckles and things of that nature, copyright protection is not a great deal of use in protecting useful articles. The Copyright Office has got rules that if something looks too much like a trademark, then you cannot get copyright protection for it either. In terms of a trademark, the basic requirement in the United States is still one of use. We have the possibility of filing a trademark application if you have a bona fide intention to use. But before the registration can go forward, except in the situation where it is based on a foreign registration, you must have actual use of the product in the market. And in order to get trademark protection for the design of a product, the Supreme Court has said you must show that that design is distinctive of the product and its source. And it specifically said, designs are not inherently distinctive. Almost invariably, they are not intended to identify the source, but to render the product itself useful or appealing. So in the Walmart case, which was on clothing, they basically put a limit on the situation in which you can get trademark protection for a design of a product until you have established distinctiveness in the marketplace. So you start off by selling it, and then eventually you can get trademark protection for it. And this is where design patents come in. Because what is frequently done is you file an application for a design patent. That goes through reasonably quickly. You establish use in the market, you build up your use, and then you file a trademark application for it, and the trademark application can go on forever. Your design patent dies. But it is a patent. And that is where I think there's a significant difference between what happens in the United States and in some other countries. The bulk of the basic patent law applies to design patent protection. Major differences: the term of a design patent is only 14 years from grant, as opposed to 20 years from filing for a utility patent. There's no publication of the application at 18 months from filing, as there is for most utility patents. Convention priority term is 6 months. There are no maintenance fees. And additionally, the design must be original and ornamental, as well as being new and non-obvious. Up until March 16th, there is a further difference which people should bear in mind, particularly if they're thinking about whether to file a US design application before or after the March 16th change of the law, when the final provisions of the America Invents Act come into place. At present, the law in the United States is that if you have already secured design protection on which you are capable of suing for infringement in some other country, and you do not file your US design application within 6 months of the filing of that application which gives rise to those rights, then you are dead under what is currently 35 U.S.C. 102D. 102D is repealed as of March 16th. So if you have a design which has already been granted in the European community, and the European community designs go through quickly, then you may already be too late to file in the United States unless you're within 6 months of that that community filing date. Because we have a design patent system, we have to have a claim. And that claim is defined in the rules as to the language it's got to be. It's got to be to the ornamental design for an article, whatever that article may be, as shown, or if there's some description in the application which you're entitled to do, as shown and described. You're entitled to only one claim, and that basically means that you are forced ultimately to construe what is shown or shown and described in order to determine what the scope of protection is. Now, this use of the word for in that definition, design of an article, design for the article, is important. Case law has distinguished between the use of the word for in this point and the use of the word of. And basically says you don't have to have the design of an entire article in order to get protection. You can get protection for aspects of the design by saying that this is the design for this article. And we'll look at some of the Apple patents in a minute which show how that has been used. Typically, what one does in order to take advantage of this provision is to show unclaimed parts of the design in broken lines, and then to include a statement in the patent saying the parts shown in broken lines form no part of the protection I'm claiming in this application. The statute also requires that the design is ornamental. And case law basically has led to imposing two requirements in this. One is that there must be something about the design which people want to look at. And the leading case on this was In re Webb, which was about a hip joint. And the Patent Office had said, no way can a hip joint ever be an ornamental design. Went up to the Federal Circuit. The Federal Circuit says, no, we can conceive of situations where what it looks like could have been important at some point in the life of that design, and if the applicant can produce evidence to show this, then that meets the ornamentality requirement. The other half of the ornamentality requirement is that the shape in question should not be dictated by the function which the article is to perform. And case law on this has sort of watered things down over the years, and so in the case of LA Gear against Tom McCann, where the design was basically for the arrangement of certain functional articles on a shoe. And the Federal Circuit says, just because all of these features are functional, it doesn't mean the way you've arranged them on this particular shoe is itself dictated by function. And when there are multiple ways of achieving the same function, then it is unlikely, I'm not saying it's impossible, but it is unlikely that the design is dictated by function, and so it does fall within the definition of what is ornamental, and you can proceed. The test for whether something is an infringement of a design patent is, however, back to something which looks very much like a trademark definition. The case is Gorham against White, which was in the 1880s. The original Mr. Tiffany was an expert witness for the defense, pointing out all sorts of differences in the design of the handle of a knife and fork from what was in the design patent. He said, everybody realized these are different. The Supreme Court said, no. You're being too detailed. The person we've got to talk to is the ordinary observer. And if the ordinary observer would be induced to purchase one of these articles thinking it was the same thing as was being patented, then there's infringement. The Contessa Food Products case against Conagra emphasized that one's got to look at the totality of what is in the design patent when one applies this ordinary observer test. This is the patent in question, and you can see it was for a method of arranging shrimp on a plate, and it's quite common in the United States to go into a supermarket and find an array of shrimp sitting on a plate, very often looking like this. The back of the plate of shrimp, however, was also shown in the patent, and so was the side, and everything is in solid lines. The infringer had his shrimp arranged looking like that so that everybody could see them and buy them thinking they were the same as the things in the patent. But the back of his plate didn't look a bit like that. Held, no infringement. Big discussion starts at that point after this decision. What should he have done? And the answer is what he should have done, of course, is to show the back of the plate in broken lines. And this is what Apple has capitalized on. Question as to who should be regarded as being the purchaser. The Goodyear tire against Hercules tire case, the design was simply stated to be for a tire. The alleged infringement were for truck tires rather than for car tires. The court got into a big discussion about whether the ordinary purchaser was a purchaser of tires in general or whether it was a specialist purchaser of truck tires. The court said, specialist purchaser of truck tires. So the specialist purchaser of truck tires will take note of certain differences which the ordinary car driver perhaps will not take notice of. So that is relevant to determining whether there is infringement or not, and whether the ordinary observer will apply a test which looks at some of the differences. When doing this, one's got to look at the ornamental features of the design as shown in the drawings, and also to any other features which are shown in the drawings, and this is back to the shrimp case. For a while, we started to move towards the idea that there might be some additional test in determining infringement as to whether you've got to look at what points of the design were novel. So we are dealing with a patent statute. Novelty is a requirement for all patents. And the courts started applying a comparison of the points of novelty test. That was squashed by the Federal Circuit in Egyptian Goddess against Suisse, which was a patent on nail files. And basically, what the court said here, which ties in with what I just said about the tire case, is that you look through the eyes of the ordinary observer. But if there are a lot of similar designs sitting out there, then you're going to take more notice of the detail than you would do if this is a one-of-a-kind type product. So to that extent, the prior art is relevant to the claim construction for the design, but it is not overriding as the claim construction for the design. In Crocs against International Trade Commission, a fairly recent case before the Apple-Samsung cases, these were the Crocs shoes which have got little holes cut in them. The alleged infringement had holes in different places from the Crocs shoes, and the shapes of the holes weren't quite the same. But the Federal Circuit says, no, this combination of old features, and having holes in shoes is old, doesn't mean that the overall appearance is lacking in novelty, and that the overall appearance cannot be found to be infringed by something which generally looks similar. And so in that case, it was found that there was infringement. And these imports were banned by the ITC to enforce the patent. In Richardson against Stanley Works, on the other hand, too many of the distinctive features were regarded as being due to functional requirements, and so under those circumstances the Federal Circuit found that despite some overall similarity in the shape of the tools, and this was a hammer with various things attached to it, the points of similarity were dictated by the function which the design had to, the product had to perform, and therefore that would not be found to be an infringement. So we get to Apple against Samsung. First two patents look at D593087 and D618677, both found to be valid and infringed by a jury in the Northern District of California. The Federal Circuit, in dealing with an appeal relating to the possibility of an interlocutory injunction, an interim injunction, points out that both patents claim a minimalist design for rectangular smartphone consisting of a large rectangular display occupying most of the phone's front face. D087 claims a bezel surrounding the perimeter of the phone's front face and extending down the front phone partway down the phone's side, and 677 does not claim a bezel but instead shows a black, highly polished reflective surface over the entire front face of the phone. That is the first of these, and as you can see, really about the only thing there which is shown in solid lines is the button at the bottom of the phone and the bezel running around the edges of the phone. The rear views, pretty well everything in broken lines except for figures, what are they, 7 and 8, which show that bezel. 6198677, only thing there which is solid is the black surface of the phone. Everything else in broken lines. Is a picture of the back of the phone in the design patent. So both of these found to be infringed. The third design patent, which was found to be infringed, and I think we have a picture of it coming up in one of the later presentations, was basically the arrangement of the icons on the screen, and the only thing which was shown in solid lines was the arrangement of the icons. The actual shape of the screen itself was shown in broken lines. All of those found to be valid and infringed. So how do you obtain broad protection for design patents in the United States? Use broken lines, obviously, is one way to do it. The other way is to put multiple embodiments of the design in your application, and then, when the Patent Office raises a restriction requirement, argue against that restriction requirement. That means that your claim has to be construed broadly to cover everything which is common to those two designs, or multiple designs, the multiple embodiments, and therefore you get broader protection that way. The risk, of course, of broken lines, the risk of multiple embodiments. The prior art might fall within the scope of the claim that you are now seeking. And this being a patent, If the prior art falls within the scope of the claim, that claim is invalid. So one has to be careful. Since we're running a little bit late, I will skip most of the other points I want to make here, except the point that the quality of the designs, the actual drawings, the figures, is very important in the United States. It's the one thing that the Patent Office will raise objections to all of the time. And many of the things which we see coming out of Europe, where they've been perfectly satisfactory for OHIM, are totally unsatisfactory for the United States. So that is something to be very careful about. The other sort of final comment I would make on the question of use of broken lines and multiple embodiments is that at some point the court is going to get into this and start to get concerned. The thing which caused KSR, in my view, and the raising of standards of obviousness in utility patents in the United States, was an article in the Wall Street Journal attacking a peanut butter and jelly patent. And that created such a swell of concern about what seemed to be trivial patents in the utility field that the Supreme Court in the end felt it had to step in. I wouldn't be too surprised if patents which just claim the radius of curvature of the side of a smartphone might not, in the end, provoke a similar reaction. But for the time being, it's not there. You can take advantage of broken lines, you can take advantage of multiple embodiments, and I urge you to do so. Thank you.